Karen Goff is the next moderator. She will take over.
Good evening, everybody from London. I had a big debate about whether I'd put a sort of screen behind me, and it probably would have been a best bet because the sun is just going down in London. First of all, thanks to Christopher Malcolm for arranging the conference. Since the world can't come to Jamaica this evening, he's brought us all online together, which is a lovely experience. So I am Karen Goff. I'm an English barrister. I'm an attorney at law with a license to practice in the islands of Jamaica and also in Trinidad and Tobago. I'm a chartered arbitrator, a past president of the Chartered Institute of Arbitrators, and an accredited adjudicator.
Practice. We would target 5 matters every year to get them fully into the system for trial and get them out of the system. And you could actually have an income stream called high court litigation. Sometime in the 90s, after the courts, a separate court of appeal was created, one started to notice some rather unhealthy trends, which culminated into you start to see delays, inexplicable delays, not necessarily from the Court of Appeal, but from high court judges and disgruntled clients and lawyers recognizing that if this trend were not halted, it was going to be difficult to continue to make a worthwhile living at the bar, which is precisely where we have reached in Barbados now. And there is dissatisfaction with the bar, with the pace of matters in the court. You're in, but you cannot get out. And we haven't yet, unfortunately, made the full transition over to ADR. They're still tentative. We are very tentative in our movement there. We have tried mediation with some measure of success, but I think the problem there is the bar. A lot of lawyers see it as a threat to their livelihood. They don't see how it can assist in the resolution of disputes in which they're part of. And indeed, in one matter in which I was involved, which was, let's say, 2 steps away from resolution, the lawyer recognized the client was having a significant say and that his role had been minimized. And typically, he just responded and broke up the entire process, and the matter is now dragging its way through the courts to the satisfaction of no one. So we have still to come a long way over into the ADR. I would say, thanks to you and the others, we have an impressive cohort of lawyers who have been trained in mediation, in arbitration, less so in mediation. So we have to increase those who are being exposed to a mediation. And hopefully in another year or so, we may just have on board enough qualified persons to offer a high quality service. But the court system of itself has almost come to a screeching halt in several areas, which is very, very sad, because it means you have highly disgruntled litigants out there, and hence my point that they would not be reluctant at all to jettison the court system. But we all know that in reality, you're going to still have to rely on it. So that's my.
And I suppose that's a good point of departure almost when we're looking at what is happening in the Caribbean, and perhaps from another perspective where Alexandra is from, where she's at least in a system which appears to be working much better than ours, with delays and so on not being as much of a problem. Perhaps there may be lessons there that Alexandra could point to speak to more pointedly, that we could ourselves look at in a common law context, whether or not, for example, the question is whether the civilian tradition, by its very nature, makes it easier for, the move into greater use of ADR and better use of that for the movement of matters through the process. And perhaps Alexandra could comment upon that and her own experience, primarily because she has experience in both traditions.
Thank you, Christopher. Let me perhaps first just go back to an important point that Pat has mentioned, which I also witness in my jurisdiction, is the resistance of the lawyers to move to ADR. And I must say that this is not only that I've witnessed that among lawyers that do litigation before state courts, but also from arbitration petitioners that tend to sometimes dismiss mediation and other form of ADR, thinking it's maybe a waste of time or it's not lucrative enough. And I think we should really work on also going against this resistance, but I think we'll be forced to, because there's going to be a huge push in that direction, also by in-house counsels and users that are just, want other forms of dispute resolution than litigation and arbitration. And I was speaking to an in-house lawyer recently who had conducted a survey among in-house lawyers in the Geneva area, and they were unanimous in saying that they had more better results in direct negotiation with their counterpart than in going in arbitration or even mediation. And in the current context, this is a trend that we'll get to see more and more. But coming back to your question, Chris, I believe that, yes, some examples can also be taken from the civil law system. As I explained in my presentation, the culture in the civil jurisdiction is a bit different, where, as you know, we have an inquisitorial system where the judge takes a more sort of proactive stance than in common law system, which is adversarial, and the judge, I'm exaggerating, but sits there and let the parties fight and just come out with the judgment at the end. And I think, and that's also the beauty of arbitration, where there's a mix of cultures, where actors and lawyers and arbitrators come from different culture, and we can learn from one another, and perhaps through this means common law lawyers hopefully could also go a bit in that direction of providing adjudicators, be it state court judges or their arbitrators, with the courage of taking a more proactive roles in facilitating settlements among the parties. So perhaps I would say going more into that direction of settlement facilitation.
There is a comment I see here coming from Elaine, that in the context of Jamaica, there appears to be some level of resistance from lawyers to the use of ADR in its more expansive vein. And I suppose the question coming out of that, and perhaps Carlos, you could look at that, bearing in mind your own experience in Florida and elsewhere, what it is that can be done to get more lawyers on board and more supportive of the process. And I particularly mentioned that to you, Carlos, knowing that Justice Silverman, for example, who has made significant comments, he's a great pusher, as you know, of mediation in the context of Florida, about how helpful and useful it has been in dealing with backlog and related issues in Florida. What is it that can be done to get lawyers more on board? And how can they be incentivized, if that is the right word, into understanding the benefits that could accrue to them from greater use of dispute management and ADR in its broadest sense?
Well, thank you, Chris. In Florida, I think as many of you know, about 7 or 8 years ago, maybe more, maybe 10 years already, we developed a division of our complex commercial litigation division that focuses only on arbitration cases. So we have 3 or 4 trained judges, and have been trained by various institutions to hear arbitration cases. So all the arbitration related cases, interim measures, these gatekeeper issues that are referred to earlier, confirmations of awards, all types of cases that have to do with ADR get referred to these particular judges in our judicial system. And as a consequence of that, not only are the judges trained, but the lawyers who have to appear before them, as Pat mentioned in one of our preliminary sessions, we have to also convince the judiciary and the lawyers that they can't make a living out of this. You know, that getting involved in EDR, getting involved in mediation, getting involved in arbitration cases doesn't mean that they're going to be out of a job. There's a role for them to play also in that context. So those are important categories that I think are responsive to your question, Chris. If I have just another minute, I wanted to just briefly talk about the arbitration process in general and the remote mediation, remote arbitration process, whether you call it virtual or not. And just simply point out also that, as we know, under the New York Convention, inappropriate or unusual or problematic procedural process can lead to the setting aside of an arbitration award, and that's under Article 5, 1B and 1D. The point is, however, that very, very few cases have been heard that challenge the arbitration award or the finality of it based on the fact that it has happened through a remote or virtual session. There's only one case that I know of where that issue was addressed, and that was about 6 months before the pandemic hit. And in that case, the court held that the fact that parts of the hearing were held remotely was not a problem, and that was not a basis for setting aside the arbitration award. So that goes into the training part also, and the fact that the judges and the lawyers need to understand that what we're doing now here and what we have done before already, I'm sure many of us have, in hearings and in mediations via remote proceedings, is an appropriate way, provided that the basics of due process are observed. So that's, I guess, part of the answer that I have for your question, Chris. It's training and convincing the lawyers that they can make a living out of this, and that the virtual and remote world, many of us think is here to stay.
Still on mute. But there are two things, Carlos, in relation to the last point you made, which I'd like to bring to the fore and to have your thoughts on. One is that there's a recent decision coming out of the Turks and Caicos Islands, where their court has effectively indicated that while you may have virtual, even if virtual is possible, let me put it that way, virtual still requires that your judge be in the Turks and Caicos Islands. And that if you're outside of it and virtual, then you're not, effectively what you're doing is not in keeping with what is required. But more importantly, from an arbitration perspective, under the LCIA, London Court of International Arbitration Rules, for example, if you look at Articles 14 and 16 and others, there's specific reference and requirement that the hearing, even though there's some latitude given to the arbitrators in terms of venue, there's specific reference indicating that the venue shall be at a geographical location. That is a language use, a geographical place is the language actually used under those rules. How do you then, where you have one party who may not want the process to go on and is insisting that I'm not going with anything virtual, how do you then deal with those difficulties in the context of the current situation that we're in? And is this a matter that an arbitrator could then proceed and find that there's a significant procedural defect in any decision that has been made?
I think, Chris, that notwithstanding that rule, LCI Rule 14 in particular, the ICC rule has ICC Rule 22 has a provision similar to that one. The UNCITRAL rules, I think UNCITRAL Article 15 also has a similar provision. I think that at the end of the day, those rules will be read in the context of due process as that concept is defined in the seat of arbitration, or where it is that the arbitration is going to be confirmed, or vacation of the award is going to be sought. So as long as the judiciary at the end of the day looks at the virtual proceedings or remote proceedings and applies a due process lens to it, I think those rules will be adapted to fit the due process conclusions that the judiciary makes. And in my opinion, I think it's going to be hard for most courts to set aside an arbitration award, provided that the arbitration hearing, virtual remote, is conducted with a modicum of due process and fairness. and an opportunity for the parties to present their case. And I think in part that's going to be because of the fact that the courts themselves, right now, certainly in the US and in many, many countries, I think perhaps most countries, are having hearings remotely. So it would be a bit hypocritical for the courts to say, you know, we can do virtual hearings, but you, the arbitrators, cannot. So I think that, you know, in answer, Chris, I think at the end of the day, we're going to see a broader acceptance to the role of the arbitration tribunals in a remote or virtual setting.
I mean, in the last minute that we have, I mean, just in response to that, Carlos, and there's a comment, and you could all three think about it in the interim, that has been asked about commenting on the enforceability of online arbitral decisions or virtual arbitral decisions. But there's something, though, in relation to what you just said about the hypocritical nature of the courts, in and out of the courts, because we have always operated on the basis that while the courts are constitutionally able to make all sorts of decisions because they have a constitutional right of access and all the things related to that, the courts have traditionally operated on the basis, and we've seen enough decisions at appellate and other levels indicating that while there may have been procedural defects, if the substantive decision is good, then you can overlook the procedural defects to get there. But we've always in arbitration operated, however, on the basis that where parties have given up their constitutional rights of access and so on, then the least they are entitled to is due process and a recognition that whatever they have contractually agreed to must be adhered to strictly or be itself a basis on which a decision could be challenged. So I think that is a struggle I suspect that the courts will have to look at, notwithstanding what they are themselves doing. It is a question of where arbitration or mediation or whatever else is accessed simply because it's a contractual right that persons have agreed to. How do you then, as a court, do anything except enforce the contract as has been strictly agreed to? And of course, if people have agreed to rules, those rules are by extension accepted as part and parcel of the terms of their contracts.
Yes, Chris. I suspect that as we sit here today in our respective offices or homes, there are probably very, very few arbitration clauses that contemplate or specifically address whether hearings can be held remotely or virtually. I suspect that most of the clauses that trigger arbitration are silent on that issue. So given the fact that they are probably silent on that issue, it's going to be left up to the arbitration panel to conduct the hearing in a way that it determines to be efficient, effective, and consistent with the principles of due process, especially when the alternative is to not have a hearing or to delay it to such an extent that, well, why even have it eventually, right? So you've got to balance the interest of delaying justice to the point that it becomes ineffectual with the other point of trying to advance it in an efficient, cost-effective manner. So I think that as long as the contract clause doesn't specifically address whether you can have a hearing remotely or not, and if it's silent on the issue, I think that the arbitration panel is going to have very broad discretion to do it in a manner that's fair, appropriate, and consistent with the norms of due process in the local jurisdictions.
Okay, it is for me now, and I know there are quite a few other questions that I'm seeing in the chat box, but unfortunately we have run completely out of time. Again, my apologies for having lost power and with it my Wi-Fi service at the beginning. But I must thank the panelists for what I think was a very well presented session. And thank you in particular for having taken it in stride and dealt with what we had promised that we would do, which is to continue the show going on with or without the moderator in place. And we thank you again, Pat, Carlos, and Alexandra, for what I think was a very, very good panel. And on behalf of all the participants and persons looking on, I want to thank you again for that.